supporting it.
Mr Speaker.
I call David Clendon.
Thank you, Mr Speaker. I'm pleased to take a short call on this bill, or this suite of bills as they now are, to affirm the Greens' continued support for this legislation. It's actually quite a rare day that the Greens are able to support a government justice bill throughout every reading, for the reasons, of course, that generally they fail to meet standards of good lawmaking, they fail to improve the situations for offenders or victims or the judicial system. But in this case, it is a piece of legislation we have supported and are happy to continue to support through this final reading. The point's been made, but the provisions of this bill and other circumstances could well have been addressed within the contents of a statutes amendment bill. But of course, there are time constraints. This legislation must be in place by the 1st of July this year, which is barely a month or so away. And so, of course, we're quite happy to cooperate and to see this legislation go through in time to ensure that the original legislation is enacted as was intended at the time. So it's true that the purpose of this legislation is, or the original legislation, should I say, the principal legislation, was to improve the efficiency, the effectiveness of our court processes, to remove delays from the court process. And it is well said, it's an old, well-tried cliche that justice delayed is justice denied. It is important that we get our justice system working effectively. Justice bills must be seen as some of the most important that go through this House. We make law in this place, clearly. The courts, the police and other arms of the justice system enforce that law and take people to task if the law is not complied with. We have the capacity, the state has the capacity to fine people, to deny them of their freedom, of their liberty in the extreme case. And so it's doubly important that the processes around the judicial system, the justice system generally, are seen to work effectively, efficiently and properly in order to maintain public confidence and to ensure that that confidence is well-founded. Unfortunately, at the same time that this very useful piece of legislation is put in place to minimise or at least to reduce some of the delays, some of the roadblocks to good process in the courts, unfortunately we've seen other aspects of this of policy and implementation of policy which are working against the intention of this. Issues like staff cuts in our courts. Anecdotally, we are hearing repeatedly from lawyers, from people who work in the courts, from people who have business in the courts, that the loss of skilled staff, loss of experienced staff in our courts is causing ongoing delays. Work is not being done in an effective manner. Judges' time is being wasted. Witnesses' time, even defendants' time is being wasted because of cuts to staffing. And it's critical that we don't save pennies and lose pounds in the way that if we don't have sufficient staffing, experienced, well-skilled, well-trained staffing in our courts, then the processes will fail, we'll lose the confidence of the public and other participants, and no matter what we do in legislation like this, the process will fail and be seen to be failing. Sadly also, of course, recently we've seen, and Mr Little, I think, referred to this, we have seen closures of some of our courts. We have seen reduced services at some of the courts. And the consequences of that are quite significant, not least of all for offenders and for victims of offending, again, of witnesses. Unfortunately, that's not saving any money, which is what we were told it would be doing. It is simply putting costs on other departments of the state. The police, for example, will be picking up the tab, the extra cost imposed on their budget by some perceived savings in the courts' budgets. So unfortunately, while this legislation will go some way towards to speeding up the judicial process, sadly other policies that are being enacted are actually working in the opposite direction. We could talk about legal aid, and I am aware that there is a sensitivity about that question at the moment. Unfortunately, the government has found itself on the wrong side of a legal judgment. But more generally, there have been cuts to the availability of legal aid, and that has negatively impacted on access to the courts. We are hearing this again from participants, and it's not only beneficiaries or low-income people or unemployed people. It is Middle New Zealand that is discovering that as the access point, the entry point for legal aid is being made more difficult, that access to the courts is being denied, access to representation. The intention of this legislation we have before us is to speed up the processes of our courts. Self-litigation will do nothing to speed up the process of our courts. Quite the contrary, it will slow it down. And the cuts to legal aid will inevitably lead to more self-litigation in the courts. We are told that some of the difficulties which this legislation endeavours to overcome but cannot do entirely, that some of the slack will be picked up by NGOs, by the community law centres, for example, who unfortunately have had no funding increase for something like 7 years. In other words, their funding is being cut. So while we might like to pass legislation, to streamline legislation, to make our courts work better, if we don't support the infrastructure around public access to the courts, then our work will be in vain. Sir, I could critique the government's judicial approach all night.
Sorry to interrupt the honourable member. The time has come for me to leave the chair. This debate is interrupted and set down for resumption next sitting day. The House stands adjourned until 2 p.m. tomorrow.